first case to come before the court is State versus Pertee.
Yes.
And Mr. Medved, it's just you arguing this morning, so you'll have your 15 minutes.
Thank you very much. I apologize up front, I'm fighting a bit of a head cold.
Well, I apologize, it feels musty, and I don't know what else in here smells musty and everything
I can't
else.
smell anything, so we're okay there.
So hopefully it won't hurt your head cold there.
Thank you. Yes, may it please the court, I am here representing the appellant, Kelly Jo Pertee, and Mr. Pertee has appealed the trial court's finding forfeiting $2,517 as a proceeds of a criminal act. The trial court, I think, committed error in finding that this should be forfeited because I don't believe that the state presented any credible evidence that the money in question was the proceeds of essentially a drug trafficking charge, I think is the implication. He was indicted on possession and trafficking charges when he was pulled over. The forfeiture hearing consisted of only the testimony of the police officer who arrested him, and the arresting officer testified that Mr. Pertee had an explanation for that money at the time. The arresting officer did not present any evidence of, there was no evidence supporting a trafficking charge beyond possibly probable cause. I'm not challenging the seizure at all under 2981-3. I think the probable cause to seize and the probable cause for the trafficking indictment were probably there. When we reached the point of plea, this did not obviously go to trial. I don't think that they had presented any evidence that would have supported a finding of trafficking, which would have been in support of the finding that these were proceeds from such a trafficking offense. The drugs seized were marijuana and hash, while the arresting officer states that it was a large amount of hash. He does not state that this was an excessively large amount that would have given a presumption to trafficking charge.
And of course, like you said, he didn't charge him.
He didn't charge him. There was an indictment that came out, but and the explanations were that they found $1,517, I believe, in his pants pocket, which he stated he had just returned from a vacation, and then he had $1,000 in his pocket, which he stated were a birthday present. It was actually his birthday when Mr. Pertee was arrested.
And the hash tissue was his birthday present too.
Yes, it's a nice.
It's
a nice holiday.
Either nice friends or really nasty friends.
Yes, I'm not making judgment on that at this point, but regardless of that explanation, it was in the state's responsibility to do something to refute that or to discredit that in any way.
The state says that his explanations kept morphing.
And I have a question about that because the state's brief claims that these were morphing testimonies, basically because it seems that on the one hand he said, I don't think there's ever dispute that the money in his pocket was, I think that was a consistent statement that this was from his vacation. We're talking about the $1,000 in the pocket, and the state's claim was that it's an inconsistent statement to say this was a birthday present versus saying this was a birthday present for my brother. Those actually seem consistent to me.
Except that he didn't say anything about the $1,000.
He did not disclose that, and I understand that, but there are also numerous reasons why you might have chosen to keep $1,000 in your pocket if you thought you were not going to be all day, and if you did not, I'm not going to go so far as to say, oops, I forgot $1,000 in my coat pocket, but if I'm not saying that is a good thing that my client did. I'm simply saying that it does not give rise to evidence that was a trafficking charge. Whatever the reason behind that, I think that you're imputing, that the trial court would be imputing a great deal to decide that he kept that $1,000 because it was trafficking.
Now, remind me, on this matter, Did the trial court actually conduct a trial on the specification?
Yeah, there was a hearing on the specification, solely the evidence of the police officer. And in that hearing, the officer does not present any evidence connecting this money to any act of trafficking, and not even to a preponderance level. I think that you have a collection of drugs, and I believe the only other materials that would be related to drug use were rolling papers and a grinder, which are all evidence of personal use, not of trafficking. There were no scales, there was no cell phone, there was no other record, there were no baggies for dividing up drugs outside the 2 baggies of marijuana that he had on his possession. There was nothing to indicate this was a person trafficking drugs, that other than the cash. And I think the law is pretty clear, the cash itself is not even in large amounts, is not evidence.
And so at the hearing, your client did not testify? Is that
The
correct?
client did not testify.
But the officer testified as to statements that the client made?
Yes, and obviously I'm appellate counsel, and so I'm somewhat of a disadvantage here, that there are statements regarding that being a birthday present from the brother, which are brought forward by the prosecution in questioning, in the testimony, but where those statements come from and how they're imputed to my client is unclear from the record. I have to admit that I don't know if those were conversations that happened off the record prior to hearing, or where we reach that point where there are these inconsistent statements regarding the nature of the birthday present.
There's no question, I take it, that your client did not have full-time employment?
That is not disputed,
Okay.
no. But he also does not claim that these are money that he had gotten through business, through any employment. And that I believe he stated he was on disability and that he had gotten back from vacation. These were money that he took with him to vacation, at least a part of that. I think and the law is clear. I think in some of the cases, in fact, that the state cites, that the court can be suspicious of the motives, of the source of the cash, but without some evidence raising to a level of preponderance of the evidence, you can't, the forfeiture is not appropriate. And I don't believe that the state has reached that point here. I think that we're at a point where there was cause to seize the money. There was cause to indict on the trafficking charge, but now we're caught in they didn't go forward on the trafficking charge, and we're in essentially a limbo area where the state has a lower burden, but it's still their burden to prove the trafficking charge, or that these were proceeds from some trafficking offense. And
so you're conceding, in a sense, probable cause for the seizure, but arguing that the state failed to establish the evidence by preponderance.
Exactly. I think that I don't think they're challenging that this was an improper seizure, or that the indictment, there was insufficient evidence to indict on the trafficking charge. But as the prior appellate counsel wrote, and it's clear law, the indictment itself is not evidence either, that you can't simply rely on. And those are the only 2 facts in this case that point to forfeiture or point to trafficking are the cash itself, which is not evidence of a crime, and the indictment, which is not evidence of a crime.
Unless you find that there are all these inconsistent, or whether you can serve an inconsistent, all these different explanations, circumstantial evidence.
And even there, in reading the transcript, and again, if you find that inconsistency, what takes its place? I mean, is there sufficient evidence, even if my client had made no statements about the source of the money at all, to say that the mere presence of personal use drugs and $2,500 is evidence that $2,500 is evidence of drug use? Because the state puts forward no evidence toward its explanation outside that. is there's an absence of nexus between the money and any offense. I mean, and that I think is your standard here, is that there's no credible evidence to support the finding. And I think this is a case where there is no such credible evidence. That even in the absence, I mean, essentially, Officer Rhodes basically confirms the facts that there were drugs there and that there was money there. But how you get from how that is connected is not supported in any way. I believe I'm about out of time.
You have a little bit more if we want to just.
I don't know what else I could tell you.
I was going to say, we just want to sit here.
You just grilled
One-
me for a while.
One day, Richard is going to show up and I'm going to be able to reserve some time to rebut.
Well, some people have tried to rebut themselves, so if you'd like to attempt that this morning, we'll have it on film, on camera here for YouTube, so it'll be very interesting.
Thank you. I'll see the rest of my time.
Okay, that sounds good, that's Steve. Thank you for your presentation to the court. We'll take the matter under advisement and issue a written opinion that will be sent to you.
Thank you.
Thank you.